The Justice and Constitutional Development Department says it will release the Whistleblower Draft Protection Bill for public comment by the end of the year. The bill follows the State Capture Commission's recommendations contained in its report released in 2022 that whistleblower legislation be amended to provide increased protection. For more, we are joined by Director for Dispute Resolution at Cliffe, Dekker, Hofmeyr, Sentebale Makara. Sentebale, good evening. Thank you so much for your time. Really do appreciate it. Perhaps frame for us what those key recommendations were that were made by the Zondo Commission report.
Thank you very much, Oliver. Well, one of the things that the Zondo Commission looked at the shortcomings of the current legislation. As we have the Protected Disclosure Act that firstly deals with an employer-employee relationship, which is very problematic in the context of whistleblowers because third parties are not covered, contractors are not covered, only employer-employee relationship. So one of those shortcomings is the fact that there's no protection with regards to your anonymity as a whistleblower, therefore confidentiality is compromised. But more importantly, there's no structured system or procedure allocated in the current existing legislation that deals with these issues. Among some of the other issues, as you would have picked up with many of the challenges that has come with whistleblowers' disclosures, and also they have a burden with regards to them having to actually be the ones that actually protect themselves with regards to the burden of proof for the disclosures that they make, and they don't have to enjoy the protection. And obviously it also becomes a very costly exercise, especially with the likelihood that it would inevitably, as we've seen in recent times, where your job might be compromised, but more importantly, loved ones. So there's a loss of income risk that's there, that's been recognized, that is not protected currently on our legislation. The breach of confidentiality, as I've said, is an issue. And also from the basis that you don't have the full cover of what a whistleblower would be in accordance with international standard.
Let's talk about that breach of confidentiality for a while, because it can become quite murky, particularly where the information that is being disclosed and or the whistle being blown upon is information that doesn't just give a sense of potential wrongdoing or impropriety that's taking place, but may also release what is sensitive corporate information which could prejudice an organization, in this instance, the employer. Does the legislation at the moment draw a distinction between that?
Well, the thin line about it is that what is lawful or lawful disclosure? Lawful disclosure is on the basis that you need to have your protections against defamation, one of them being, for example, truthfulness of what you're disclosing. So there's that criteria as well as an extra hurdle on whistleblowers, as we've seen with current cases that come in where whistleblowers are being sued for defamation for some of the disclosures that they make. The current requirement is that it must be disclosures made in good faith. Now, that also further puts another burden on whistleblowers, because what it then does is that it requires the intention of good faith. So therefore, the incentivization of whistleblowers, as you would see in international standard, is still not recognized. That does create a certain challenge. Now, the Protection of State Information Act, for example, is one legislation that seems to be also muddying the waters in regards to this, which maybe does require reform on the basis that currently a whistleblower, like for example with corporate espionage or where there's corporate disclosures being made, there's no protection in the sense that the employer can still come after you for that disclosure, similar to if you are a state employee and some of those disclosures that you have form part of national security, you might be still persecuted by your employer. But more importantly, it still deals fundamentally with the issue that we still recognize it in the context of an employer-employee relationship. What happens to a third party that happens to get information that actually pertains to a specific organization? What protections do they have? And our current legislation doesn't necessarily carry that.
Yeah, Sentebale, just on that, if your employer could pursue you in a defamation suit, that could have its own implications, and oftentimes the implications there are civil in its nature. But they could also pursue you under a criminal injuria regime, which the implications therefore are criminal, which are perhaps a lot more far-reaching, because if it's criminal injuria, it invokes their protections of privacy that are inherent to our juristic existence, particularly as an organization where some of your corporate information is covered by privacy. What sort of protection is there for employees from criminal pursuits rather than just a civil pursuit?
I think it boils down to exactly why there needs to be reform, as was recognized after the Zondo Commission, for example. We had a discussion document that was released by the DOJ, which recognizes this issue that currently in the current legislation, there is no obligation on the person you are disclosing to keep you confidential. As a consequence of that, you now sit with
except in the instance of the media, the journalistic code does require that we protect the confidentiality of a source.
Well, that be true, but at the same time, the source. But remember, the source there is not in the context of being a whistleblower. That's an confidential informer. The problem with a whistleblower, the context of it is slightly different from a confidential informer that would form part of what would be the journalistic ambit. We would then enjoy the protection from the journalist itself that can't be compelled necessarily to reveal their source. Here you're sitting with a whistleblower informing to an employer or an accounting officer in an organization. That accounting officer doesn't have an obligation to keep you anonymous, which in any event then does actually invite certain persecution, such as the risk for criminal liability, as you've raised, but also civil liability. Because even on the civil context, as I've said, your defense would be truth. On the criminal aspect as well, your defense would be truth. But now you're still lumped with the burden of you having to protect and prove the disclosure's truthfulness as well as a whistleblower, which could be cured by being protected from your identity.
Just one word answer, which country has the standard for best practice that we ought to emulate at the moment?
Well, I would not say necessarily one country specifically, but a body of countries that seem to have started working on recognizing that there's certain inherent dangers with being a whistleblower, and certain other third parties, like your family, for example, as a whistleblower.
Okay, what's the group of countries?
Yeah, so the group of countries, you would look at the USA.
Okay.
You would look at, for example, you would look at England as one of them, for example. Switzerland also has some good legislation coming from them. A couple of the UK countries as a collective do have but there's some work that needs to be done even there. But we recognize the fact that they've gone a far long way in protecting it, because there's quite an integration between their witness protection and understanding what the role of whistleblower is.
Sentebale, I'm going to have to leave it there. Thank you so much for your time. Really do appreciate it. Sentebale Makara is with Cliffe, Dekker, Hofmeyr. He's the Director for Disputes and Resolutions there.